Welcome back to one more session. Today in this video I am going to explain about administration of justice. In the words of Professor Sidgwick, he stated that in determining a nation's rank in political civilization, no test is more decisive than the degree in which justice as defined by the law is actually realized in its judicial administration. The most essential functions of a state are primarily two: war and administration of justice. The administration of justice implies the maintenance of right within a political community by means of the physical force of state. In the history of administration of justice started with the rise of political states. However, those states were not strong enough to regulate crime and inflict punishment on the criminals. The modern administration of justice is a natural corollary to the growth in power of political states. According to Salman, the law is without doubt a remedy for greater evil, yet it brings with it evils of its own. In modern times, what is given by the courts to the people is not what can really be called justice, but merely justice according to law. Judges are not legislators, and it is not their duty to correct the defective provisions of law. They are just interpreters. Their only function is to administrate the law of the country. They are not expected to ignore the law of the country. It is rightly said that in the modern state, the administration of justice according to law is commonly taken to imply recognition of fixed rules. For example, a creditor has to realize some money from a debitor. However, he files after the lapse of 3 years. Equity may be on his side, but his suit must fail on account of the law of limitation, which demands that a suit must be filed within 3 years. And another example, a person may have actually committed a murder. He may confess his guilt before a police officer who is an honest man. However, he does not make a confession before a magistrate. If he is convicted on the basis of his confession before the police officer, his conviction has to be set aside as it is opposed to the law of the country. Even if a guilty person escapes, judges are not bothered about it. They do not play and are not expected to play the role of the legislators. If law is defective, it is the duty of the people to demand from their legislators to alter the same. However, so long as a particular law is not in the statute book, the same has to be enforced unmindful of the consequences. Law may be blind, and therefore justice becomes blind, but there is no help for it. Judges are expected to give justice according to the law of the country and not according to what they consider to be just under the circumstances. This is a brief with respect to the administration of the justice. So the conclusion is that the origin and growth of administration of the justice is identical with the origin and growth of man. This is a brief with respect to the administration of justice. Thank you.